Going to be able to start. So, good morning, everyone. I'm very pleased to be with you this morning for this new occasion of the ATECHEL event. Usually we have these events here at the Autorité Rue de l'Échelle in Paris, where the name of the event comes from. The last event was organized a little bit after the first confinement we had in France, and it was before last summer. We had discussed the topic of how shops could compete with online websites, and especially given the current COVID-19 crisis. So we see that this topic is still very much significant in France today. We are here now for another topic that is in relation with the way the economy is becoming more digital every day. And this is a really very special occasion to discuss with Andreas Mundt about the new Competition Act that is being discussed right now in Germany. This will be the 10th amendment to the most important law in Germany about competition, the Act Against Restraints to Competition. And we thought that it was really very important to have a discussion about this new law that is being drafted, and to have the expert views of Andreas Mundt, who as chairman of the competition authority in Germany will be the main actor implementing this act, and we will discuss with Andreas how the Bundeskartellamt views so far this new project that will become a law in a very short time, and how they consider the future implementation of this act. So why is this discussion so important today? The first reason, I think, that we have had in the last 4 years many discussions about platforms and how the economy changes, and whether competition law was in a good place and in a good shape to tackle those new challenges. But now we are at a different time, because governments and parliaments are taking action. And we see that Germany has been really at the forefront of changing the law and adapting the law to adapt to those challenges linked with digitization of the economy. And I think that the first important step was taken quite recently in 2017 with the 9th amendment to the German Competition Act, which had already implemented a number of changes that were quite important in the German Competition Act. I wanted to remind you briefly of these changes so that we measure what this new act will be adding in addition to that. So in this act of 2017, the law had added some additional criteria to how you recognize a dominant position by an undertaking. So according to those new provisions of 2017, the authority could take into account network effects, the possibility to use multi-homing, restriction to switching by customers, economies of scale, access to data, or competition pressure based on innovation. This past act of 2017 also introduced a very important change with the new value of transaction threshold for merger control. And finally, the last important feature in relation to digitization of the economy was the possibility to take into account a dominant position, even with services that do not have a price or a tariffication associated. So what is important about this new act that is being discussed in Germany right now? First, I would say the time when this law is coming, and the content, of course, of this law, which is very ambitious, and Andreas will be describing the main features of this act. So I think that this law is important for Germany, of course, but also for the whole of Europe, and of course for France, because I would say it is the first transcription into law of some quite important changes to competition law. You could say a different scope, maybe a different way to apprehend abuse, and also a changing of the legal framework that is quite significant and that will be going into some detail. And the second reason, beyond the impact on Germany, is I would say the impact it will have on the discussion at the European level for the DSA or Digital Markets Act, because we will see with this discussion that some of the ideas that are in the German law are quite, resemble quite closely what we find in the current discussion of the new Digital Services Act. So we might expect this German law to have an impact on the discussion at the European level. And of course, those two projects will be advancing more or less at the same time. Another important feature is that we have heard in recent months a common position by France, Germany, and Poland on how to approach digital platforms. So in that respect, France and Germany at the level of the governments try to advance, to go forward in a coherent manner. So what will happen in Germany will surely have an impact on how the French government follows those topics at the European level. So I would now like to thank very much Andreas to have accepted this chat and this conversation today. We are currently living difficult times with the new second wave of the COVID, the fact that we have been recently placed into lockdown in France. It is quite dire, and especially when you already have gone through the first lockdown to go into a second lockdown again. And I know that in many countries in Europe and beyond Europe, the situation is pretty tough. And we have had terrorist attacks in France and Austria. So it is a bit gloomy, but I think that these difficulties must not prevent us from going forward with our task. And I think that one of the most important tasks that competition authorities and governments have to tackle right now is how to adapt our legal framework and enforcement tools to the new digital economy. And in that respect, the new 10th amendment to the German Competition Act is really a very important step, because we are not discussing about reports or academic discussion, but now this will change the legal framework in Germany. So I will now turn to Andreas, maybe for a first question that would be, why has this act been prepared by the German government for many months now? What were the objectives? I know that the topic was amongst the main topic of the coalition that is now in power in Germany, and also that the government had asked some input by some academics that prepared a report to prepare the law. So maybe Andreas, if you could just start by telling us what is the context of this law, how was it prepared, and what maybe what are the next steps in Parliament to give us an idea of the time frame of this new law. So thank you again, Andreas. You have the floor.
Thank you very much, Isabel. Well, indeed, I'm very happy to be with you, and I'm very happy that we have some kind of a normal exchange between the Bundeskartellamt and the Autorité, which we are used to, in fact. You know, we have cooperated so much on so many important projects. If you think of the joint papers that we have done on big data, on algorithms, this frequent exchange between the two of us, but also between our staff and those who work for our agencies, that is really something that we miss, especially in these times when we are about to shape the new competition law, not only for Germany, but also for Europe. And this is really lacking for the time being. So I'm very happy that we have this opportunity here to do this, at least virtually. And again, in these gloomy times, as you have described it, and I feel exactly the same, it is very good to have some normal pieces of life where we discuss matters that are of great importance and that during this pandemic crisis even grow in importance. So it's a great pleasure to be with you. It's also an honor. And I would like to just, as you mentioned it, give you maybe a brief overview on the law that is about to come, about the content, about the rationale behind it, why we do it, what we do, and in how far it resembles other initiatives that we see for the time being also at the European level. The NCT, DSA, DMA, however you call it. Well, the topic today is changes to German competition law for a focused, proactive, and digital competition law 4.0. I mean, this is really a grandiose title for a law, I must say. Never seen it like this before. And I assume, to be quite frank, and I claim that we have been at least been focused and digital before. Maybe proactive was a bit different under the framework that we have. So I'll be happy to give you an overview. The topic is more up to date than ever. If you look around, at what is happening, for the first time, at least from my perception, we see serious steps in the United States with regard to a lawsuit by the DOJ against Google. You mentioned already the Digital Services Act, the new competition tool, the Digital Markets Act that is about to come in Europe. We have seen so many cases, namely in Brussels, in Paris, in Rome, in Bonn, in other capitals. What is the rationale? Why do we need to change the law? I think the underlying rationale and the purpose is the same wherever you go, whether you look at the European level or at Germany. It's the fact that we have seen many convenient services and improvements through digitalization, but at the same time, we must admit we have also faced huge problems. I do not need to sketch them out anymore. Everyone is familiar with the phenomena of network effects, familiar with the phenomenon of data-driven business models, familiar with gatekeeper platforms and the problems that might occur with this respect, familiar with the high barriers to entry that are created by network effects, reinforced by the use of data. So in fact, we are all confronted with the same phenomenon, and this is the well-known winner takes it all dynamic. And the current COVID-19 crisis even amplifies these dynamics. So what we are aiming at is, in fact, not only keeping markets open and so on, but we really need to reestablish conditions for competitive options for companies outside the ecosystem of these huge companies, the huge digital companies. There have been many cases in the past. We have started early on in 2013 with the Amazon price parity clauses. We have achieved adjustments with regard to the Amazon terms and conditions for dealers that make use of the Amazon marketplace. Just recently, the Federal Supreme Court in a preliminary decision has confirmed our view that Facebook abuses its market powers. So there were lots of major proceedings. Nevertheless, I think we all have a strong feeling that there is a need for adjustment. And this is why we are about to put the 10th Amendment of the German Competition Act into place. And I just would like to sketch out three key features that are so essential with regard to this law. The first key feature is a completely new section 19A, which some call, of which some say it's kind of regulation. I agree to a certain extent, but I think it is still deeply rooted and it is still in the context of competition law. But this is really a new section, and this is also really new for the Bundeskartellamt, because in fact, we define a new category of companies. Section 19A, the new Section 19A refers to undertakings with paramount significance for competition across markets. This is the legal expression that we have chosen. It is quite comparable to companies with a strategic market status, as you've seen it in the UK in the Furman report. Some speak about gatekeeper platforms. Well, our choice in legal terms was paramount significance for competition across markets. Generally limited to companies in the digital economy, to the internet economy. So the first key question is, what kind of new companies are we going to address? If you look at the law, you find familiar criteria. You find vocabulary like dominance, access to financial and human and other resources. You find vertical integration. You find business on connected markets, access to data, gatekeeper function with regard to access to markets by third parties. So what we have done is we have set up a working group here in the Federal Cartel Office to take a close look at how to fill this vocabulary, which sounds so traditional and familiar, but in fact, it must mean something else if you put it in that new context of Article 19A, because now Article 19A is different from anything else that we see in the law. So what we are about to do now is that we take kind of a holistic assessment of companies and their position in the market with an emphasis on the across market aspect. So to give you some examples, financial resources, we will take a look at high price acquisitions that we have seen so often in digital markets. We look at the investment in research and development. We look at patent ownership. We look at the size of an ecosystem that might have been created by a certain company. So you see, the focus will be very much on digital phenomena we know from these companies. Another example, we look at vertical integrated and connected markets. What we often find is a multi-market business case. And what we often find is that the business development on these various markets is very much driven by the huge advantages from data in these multi-market activities. Another aspect that might not be so new, but on which we will lay very much emphasis in the approach that we are going to take. Another issue will be when it comes to access to data, not only on the access, we are familiar with that, but we will look at the capability of a certain company of the monetization of data with regard to online ads, for example. We will look at the capabilities of companies with regard to data in general. We know many companies own data, but the winners are those who best know what to make out of it. So these will be the aspects that we are interested in. And of course, the gatekeeper function, the rule setting function, and this rule setting very often is accompanied by the danger of widening and protecting the ecosystem of a company. So these are the aspects that we are going to be interested in. So it's about established and digital gatekeepers, which to me is exactly the right focus that we concentrate on. The behavior that we are going to look at in Article 19.8, Para 2, also sounds familiar at first sight. It's about self-preferencing, it's about envelopment strategies, it's about establishing entry barriers related to data and hindering interoperability or data portability, just to give you some examples. But what is exceptional and what is really new and what is really more than cartel law is that in the future, we can prohibit this behavior also on markets where the gatekeepers are not dominant yet. So what we do, in fact, is we set up some do's and some don'ts on markets where these companies are dominant and where they are not dominant. So this might remind you very much of the study of Potsoon and Philip Marston, or that might remind you very much on the UK approach about setting up a code of conduct. I think the difference with regard to Germany is that our approach is maybe a bit more case-driven, but I think this will help us a lot in re-establishing competitive structures in certain markets and help those companies outside the big five. So this is the key adjustment that we are about to see. There's more in the law that we might come back later on. There will be certain provisions on data access and intermediation roles. Our national facilities doctrine will explicitly cover access to data, which is a substantial extension. There will be other points of clarifications, but I have made the experience that clarifications can be extremely helpful, although they are only clarifications because they help you in court and you do not have to discuss certain issues before the court. Another feature I should quickly mention is there will be an update of the established rules for company with relative market power. That is a specialty of German competition law that many of you might be familiar with. Addressees in German competition law are not only dominant companies, but also companies on whom another company might depend. That was until now limited to SMEs, small and medium-sized enterprises. Now the law states explicitly that also big companies can be dependent on certain companies, platforms, gatekeepers. So we have to acknowledge, and this is now acknowledged by the law, that even big companies can depend on digital gatekeepers. So we will just broaden the applicability of relative market powers in terms of dependency. Plus, there will be rules concerning dependencies on intermediaries in multi-sided markets, explicitly covering data-driven dependencies. These are the key features of the law, in fact. So in a nutshell, the draft for the 10th Amendment is quite advanced. It's a quite concrete proposal, at least if you compare it with the Digital Services Act, the new competition tool, or the Digital Markets Act. And I think it will really strengthen us in coping with big tech companies. The further schedule of the legislative process will be that the procedure has begun. There has been the first reading of the law in Parliament. There will be a hearing in Parliament on the 25th of November. And we can assume that the law will come into force at the beginning of next year. And then we will, at least I hope, properly equipped as far as the legal conditions are concerned. So this should be my introduction, and I look forward to your questions and to the debate.
Thank you, Andreas, for this very clear presentation. So maybe some reactions and some first questions about section 19A. First reaction, as I was saying earlier, it's quite interesting to see that the German legislator has chosen to give some precise criteria or example of what constitutes dominance, because we know that, for example, in European law or French law, the articles are very general in terms of having a dominant position and do not give any criteria. But this, I would say, in the 10th Amendment is similar in spirit to what was done in the 9th Amendment in terms of giving some specific example or criteria like network effects or switching or so forth. And that is interesting because it's a choice. And the criteria that you have mentioned can be based on a very significant literature or academic thinking that we have now been able to complete in the last few years. So that is in this way, the new act is in the same spirit of the Ninth Amendment. What is new, as you were saying, is maybe the spirit goes certainly beyond what is considered traditional abuse in giving the enforcer a possibility to ask the company to act in a certain way, even in a market where it is not dominant. So I had a few questions about Section 19A, and we will come back later to the other new content of the law, like concerning relative market power and also merger control, where there are other significant changes. So maybe about this notion of undertaking of paramount significance for competition across markets. As you were saying, this is something that is we could find some roots for that in the Furman report or in other reports that have been trying to define what is a structural platform, and this is new in terms of selecting a certain category of dominant firm. This is also in keeping with the tradition of competition law to have specific rules for dominant players. So there is some new and there is some classic in that. And I was thinking, it's interesting to know that you have set up an internal working group to try to think about how you will apply the law. In the proceeding of the law, could it be separate to say this company has paramount significance for competition across market, and then you would study an abuse, or will it always be at the same time that you define a certain company as fitting that framework and then looking at this conduct, or could it be separate? Could there be like a definition by the Bundeskartellamt of the companies that today you consider as fitting that framework in Germany, or will it always be at the same time when you are looking at the conduct?
Yeah, maybe, Isabel, I have to go a little bit more into the details of Section 19A. In fact, 19A has two paragraphs. Section 19A, para 1 is about the question who shall be regulated. So this is what we need to do. What we need to do first. In fact, to design or to give a clear to say clearly which are the companies that are at stake and that shall be regulated, or which is the company, I should better say, that shall be fall beyond the scope of Article 19A and that shall be regulated. So in practice, how is it going to be? Which company can fall under this category? I think obviously the potential addressees are large players in the digital internet industry, which is strongly characterized by multi-sided markets, by platforms. And it's exactly these platform markets that are characterized by the winner takes it all dynamic. One important feature for us is that companies are in a strong position mostly on various markets. It's not just on one market, but it's on various markets. And having said that, it is so that this enables them, at least in many cases that we have seen, to establish a cross-market digital ecosystem in which they have the gatekeeper function. I think at least this is our analysis, and this is what always leads us back to the across market thing. A result of this analysis for us is that market boundaries blur to a certain extent, and competition is only often possible on the margins of the ecosystem that are established by these companies across many markets. So if you are a customer of these companies, you are the customer of a whole ecosystem across many markets, and lock-in effects occur. But this lock-in effect does not happen on a certain market. This lock-in effect happens to you with a certain company. You're locked in an ecosystem that is driven by a company on many markets. And this is why we always come back to this issue of across markets, as I said. And again, all this is data driven. So you always leave your data not only to a company for a certain function, you leave it for the whole ecosystem and for keeping you locked in this whole ecosystem. So what is also very important to mention that a paramount significance for competition across markets can be held by several companies at the same time. That is a bit different from how we were thinking in the past. The explanatory memorandum of the draft law states that there is only a small number of firms that is expected to be of paramount significance, but it is also clearly said it is not only one. Also, this is an important aspect in our thinking. So again, I come back to my holistic view. When you assess a paramount significance, we need to take that holistic view. And we must also have in mind that the factors that I have just mentioned that are part of Article 19A are not exhaustive, one important point, and they don't need to be present in a cumulative way. It's going to be a case-by-case assessment based on different business models. So in a nutshell, you can say it will be important to look at the company as a whole, on its activities, on the markets, beyond classic market definition, as we have done it in the past.
And if I come back to the law, so paragraph 1 of section 19A states that the Bundeskartellamt may issue a decision declaring that an undertaking is of paramount significance across market. And in your view, are you going to try in the first months where the law becomes can be implemented? Will you be seeking to have like an extensive list of all those companies in Germany, or will you start with the most obvious ones? And will it be possible for a company to ask for a judicial review of that decision of the Bundeskartellamt, for example?
Yeah. Well, in my experience in competition law, it's never good to have a list of companies that are subject to your enforcement. But in fact, you are right. It's a two-step approach, so to say. The first step is that you designate the company that falls under section 19A para 1. That is the first step that we need to take. To be frank, I cannot tell you today how we are going to proceed at the beginning of next year. Of course, we have our internal deliberations, how we are going to do that. But I think it would be premature to tell now how exactly we are going to proceed. I said we have established an internal working group that is looking at exactly these issues. We have an ongoing sector inquiry, for example, into online advertising that will be part of our deliberations. So we must see how we make this operational from the start. But you must also see we consist of various decision divisions in the Bundeskartellamt. Not all companies are in the same decision division, so to say. So we must find a coordinated approach to a certain extent with regard to certain companies, and we will see how we do that. But this is correct. Article 19A foresees a two-step approach. The first step is to designate the company that falls under 19A, and the second approach is, well, to prohibit certain kind of behavior that is designated in Article 19A para 2.
And maybe another comment this time about the second step of this two-step approach, where the Bundeskartellamt may prohibit certain conduct. This is where the law is quite innovative because it does not state in paragraph 2 that there is an abuse, but the last paragraph states that these different prohibitions that you can issue will not apply if the respective conduct is objectively justified. So this is where there might be a debate with the company in terms of what you intend to prohibit. And I imagine that there will be a phase of debate and contradiction with the company in that respect. And this, I think, is maybe the provision where there will be a lot of academic debate about is it still antitrust or is it regulatory, and is it ex ante or ex post? I know that academics really enjoy a lot that debate. And certainly this will resemble in a way some traditional abuse cases, but it will be one of the aspects that was underlined as quite innovative is, I take the wording from the translation I have of this law, when the company wants to justify objectively its behavior, the law states that the burden of presenting facts and the burden of proof lie with the undertaking in question. So obviously, I think that this is one of the most debated aspects of the law in Germany, I can imagine, because this is a big change in terms of where does the burden of proof lie. I don't know if you want to comment on that specific aspect. Do you feel it is important in the terms of the overall objective of the law to have this change in terms of the burden of proof?
Yeah, of course. I mean, it's always hard to predict what will be really important and what will be difficult in the practical legal or economic debate. We can only try to anticipate the discussion that we are going to have with the companies that might be subject to Article 19A. So if you want to regulate as a lawmaker, what kind of behavior should the competition agency address? Of course, it is quite appealing, I would say, to have some clear categories. What is always the clear category, or the best example for a clear category, is self-preferencing, because everyone says, of course, self-preferencing by hybrid platforms, by other platforms, shall be addressed. That is foreseen in the German draft of the 10th Amendment. As far as we know today, that will be foreseen in the Digital Markets Act. At least it was foreseen in this leaked paper that we have seen on the Digital Services Act. So there is some agreement about this. And I think a clear statement that this is unlawful in the law is very helpful. But Isabel, both of us know that self-preferencing is not so easy to define. I do not want to come back to the Google Shopping case, but I heard that there was an ongoing, or not ongoing, but there's a long discussion between the Commission and the company if a certain shade of the color of gray leads to self-preference or not. So defining self-preference in a certain case might not be as easy as we assume today. Let's put it this way. I'm not saying we have to do it this extensive way in every case, but it is not going to be so easy. So having said that, this is why so far we have no automatic rules with regard to self-preference, but we as an agency have to prohibit this certain kind of behavior, which might make a lot of sense. So we can only interdict a certain specific behavior in this second step, and this will be complex. Well, since this is going to be so complex, of course there is the deliberation: how can I help the agency to come to this result? And this is why we have this certain shift of the burden of proof, which under German law is not really a full shift of the burden of proof, because under German law, the agency will still be obliged to do a full assessment of the legal and economic situation. It also means that if in the very end, after a full investigation, we come to the result that we have kind of a non liquid, that this goes to the detriment of the companies. I think for us, it will be very helpful that to a certain extent, companies will be obliged to hand over the necessary information to do this assessment properly. You know how difficult this can be in a certain case. You do not know which information is in the hands of the companies, which information is available, which information should you have, and if the company does not provide the information properly, it is to their disadvantage. It's not to the disadvantage of the competition agency. And I think here this can be very helpful, but it is important that everyone knows that we have still the full obligation to do a full investigation on the markets concerned and on the behavior that is at stake. But yes, I think this is a justified shift of the burden of proof to a certain extent. And personally, I do believe that in our practical work, this can be very helpful. And I think it does not go too far, given the fact that there's still the obligation for a full investigation.
Thank you. And maybe two last questions on this Section 90A part of the law. And I reminded those who are watching this discussion that if they have some specific questions, they can write them in the YouTube page, and they will be sent to us. First question, if a company that is submitted to those prohibition does not comply with them, will it be a classical fining system, or what are the consequences for the company if you find the company to be in breach? What will be the judicial review system for this decision? Will it be the same as when you have a decision by the Bundeskartellamt based on a traditional abuse of dominance, for example? And maybe a question about how you see the interplay between this new German legal tool and the future European DSA, DMA or INCITI framework, because we see that the inspiration seems quite close in some parts in terms of having a blacklist of things that would be prohibited. So we might have some cases in which maybe there will be a possibility of implementation at the European level of self-preferencing that would be prohibited if that is in the final text, or at the national level. So of course, those are early days, but have you been thinking about this, or is it too soon because we don't have the text yet of the DMA to see how those two will be interacting?
Yeah, thank you, Isabel. These are important questions which are difficult to answer, I would say. Your first question on the remedies or the fines that we might impose in the framework of Article 19A. Well, to impose fines in abuse cases in Germany is feasible, but the bar is very high. Let's put it this way. Usually we don't do that in abuse cases because German law is very strict with regard to the behavior and with regard if that is really worth a fine and if the law is clear enough on this behavior that exactly this behavior should be subject to a fine. That is very difficult. So normally we do not impose fines in abuse cases. Many people have been asking me if we don't miss that, looking at the high fines that the European Commission is imposing, for example, in the Google cases. I keep on saying I'm not missing that because I do not believe that fines will really do their job in abuse cases as they do in cartel cases. They have a certain deterrent effect, yes, but I think what we really need to do is to change the anti-competitive elements of business models. And this is helpful for the future. A fine always looks back at the behavior in the past. But this is not so much what is helpful. What really helps is that we change behavior in the future, or even if we take structural measures. This is why I always, in any session, come back to the Facebook case, because I like it so much. Because having imposed these remedies there and enforcing them, I always call that kind of an internal divestiture of Facebook, if they really have to keep the data separate in various silos on Facebook, on Instagram, on WhatsApp, and the data they collect on third-party platforms. This is something, from my point of view, that is a remedy that really looks into the future and is able to tackle this data-driven dominance that this company is having, you know. So, in fact, I'm not missing fines so much. It's more about that the remedies are designed and shaped in a way that they really have an impact on the market in the future. This is what counts to me, and this is what I want to do in the future. Judicial review will not be different from what we have seen in the past. We are subject to very strict judicial review in Germany. If the case goes to the higher regional court, all witnesses can be heard again. It's a full review of our case in any aspect. And I assume this will not be different from what we have seen in the past in other cases. And this is why it is so important that we also have clarifications in the law, because they help before the court. You do not have to discuss certain matters. With regard to the initiatives at EU level, that is difficult to say, because from my perspective, it is not clear yet how these new tools will be designed and what is the relationship between the new tools and traditional competition law. What I have read is that the new competition tool and the Digital Services Act will be melted down to one Digital Markets Act, which makes a lot of sense from my perspective. There will be enforcement tools that allow early intervention before markets tip. Besides, we will have to clarify what is the relationship between these new tools and Article 102 TFEU, something that is at least not clear to me. Plus, we must clarify what will be the role of competition agencies at a national level in this respect. So what will be our task when it comes to the Digital Markets Act? And the last question that, in fact, will have to answer is the question, what is the relationship between these European initiatives and national initiatives, which we might not only see here in Germany, but maybe also in other member states of the EU. The German approach that I have described so far, it differs conceptually to a certain extent. From my perspective, it bridges very much the divide between traditional competition law and traditional regulation or regulatory law. I always call it competition law plus, but we have to see how the European proposals ultimately will look like, and we must see what is the relationship between these new European regulation and national regulation in this sense. Personally, I'm a big friend of having national competition agencies involved also in European tools. We have lots of experience in digital markets. We have had big cases. We have done a lot of intellectual groundwork in this respect. We have had a real impact on markets. I think that is also a source of inspiration for the European Union. What is happening in Bonn, in Paris, in Rome, in don't know where, in the Netherlands. So you should not cut this off and leave it just to one place. Maybe competition is a good issue. It's a good issue here too. But before we can really say something on what will be the relationship, in fact, we must clarify all these questions that I have mentioned. The only thing that I know, the German legislative procedure will be very quick. So I'm pretty sure that this amendment we are discussing today will be in place at the beginning of next year, and we will be starting to enforce it. So that will be a process where we must take measures on the way when we want to make it fit with the European proposals that are at stake.
So, Andreas, I have received a copy of quite a number of questions that we have received through the YouTube channel. Maybe we'll come back to some of those in the last part of our discussion. I think we will have time. Maybe there was one question that was a bit separate, that was in relation to France. So one of the questions was, in Germany, we are discussing the reform efforts regarding the 10th Amendment, and I was asked if there was similar plans in France. So what I can say very quickly about that is that there has been a law proposal regarding a sort of regulation of platforms, digital structure or strategic platforms in France. And right now, one of the law in discussion in France incorporates this aspect, but it is not clear if it will remain in the final law that should be approved in the next few days, because there is a debate regarding the fact that Europe is having a similar discussion right now with the Digital Services Act. And the position of the French government so far is that this discussion at the European level should take precedence before a national law is implemented. So this is very much an active debate right now in France. So I suggest now that we move to another part of the law that is important, that is the new elements that are added to the abuse of dominant position. So this is something that you mentioned in your introduction, the fact that now the Bundeskartellamt will be able to take into account to assess market dominance new elements such as access to data relevant for competition and the intermediary power of platforms. And there is also a reference to refusal to access to data and in section 92 relating to access to data, maybe as a way to qualify an essential facility. So maybe I was wondering about this part of the law. Do you feel that this is really, in a way, taking some new elements that were already in the intellectual framework you were applying, for example, through the Facebook decision that you mentioned, that is of last year, 2019? And do you feel that the other part that you also mentioned, the one about undertakings with relative or superior market power, could change in nature, because this part of the law that is German and does not necessarily have equivalent in other countries, where in France we have a regime that is somewhat similar, but with some differences. Now there is an important change from what I understand in the law, because this provision used to be concentrated on protecting small and medium enterprises. And in the new drafting of the law, this condition will not remain. And I understand that now this new provision might have a much wider application. So I don't know if you feel that this is a significant evolution, and could it be also significant in terms of the digital economy, where you can have this position of relative market power without a very high market share like we have in a dominant position. So I don't know if you wanted to comment more on those two different sets of provision.
Yeah. Thank you very much, Isabel. Well, indeed, the amendment also focuses mainly on two issues that are important in this respect. One is the intermediation role that these platforms can play. And the second one is, and that is a large part from my perception, is on data access. And here combined exactly with the question of relative market power. So that is, from my perspective, the important link, that it strengthens the possibilities of granting access to data, also in cases of relative market power. I think this is important. But to make it a bit more clear, there are four features that I would like to mention. The first one is that intermediary power is introduced as a new criterion for the assessment of market power. So here you might ask, what is new about that? I think all of us who have done these cases in platform cases have done that already. So this is not really something that is new. I assume this is one of the clarifications that the legislator was happy to make, and I think this is something that might help in court when it comes to these kind of questions. But again, this is rather a clarification. What are substantial changes? And here I would like to mention three changes that are important. These are the provisions that are related to data access. The first change here is that data access is formally mentioned as a criterion for the assessment of market power. Here again, I would say another clarification, helpful before court, but not as substantial as the other two changes. The second change, and that might be of more importance with regard to the extension of our tools, is that we are going to see, you mentioned it already, a modification of the German essential facilities doctrine. According to this new doctrine, this new shape of the law, an abuse now also can exist if a dominant company refuses to grant access to data to another company against payment if the data is necessary in order to operate in an upstream or in a downstream market. And this is really new, because until now, in Germany, the essential facilities doctrine was limited to networks or physical infrastructure. So now it's going to be extended. To data, which is much clearer, by the way, from my perception, as it is at the European level, where it is clearly broader than it was in Germany. But in Germany now, it's going to be pretty clear, which we welcome a lot. The third one is this issue on relative market power. There will be the introduction of a rule on data-related dependency, which says that there will be a right to access to data if a company is dependent on the data of another company that controls the data. That means closed systems might need to open up. This is very far-reaching, indeed. We need to assess if the obstruction of data access is unfair or not. There's going to be a balance of interest, and I must say this is not really an easy task. Neither for us in the very end, nor for the civil courts who can apply these provisions as well, because this can have a profound impact, of course, on the business model of the company that owns or that has gathered the data. I mean, that attaches a lot of importance to the protection of new business models, and from my perception, it will be quite difficult to predict how this will be applied in the future in practice. You mentioned, not related to data, this new provision or the change of the provision that also large companies can depend on platforms if they want to reach out to their customers, to their clients, that there can be this kind of dependency also by big companies. We made use of it in the past to a certain sense. Relative market power in our case portfolio has always played a big role, and I can imagine that exactly this change in the future might be very helpful when it comes to new cases. But also here, that is very difficult to predict today, what will be of which importance in the future. But I think this might be a new tool that can be extremely helpful. Yes.
Thank you, Andreas. I received a question related to data access that was related to a German decision concerning energy, donc GDF Suez or ENGIE, against Direct Energy. And this is a case where the authority had asked the dominant company to give access to data to competitors. And the question is whether this case law is still relevant today, and would the authority or the courts decide differently? So I can safely say about this decision that was fully confirmed by the courts, that this is very much the jurisprudence as of today in France. And I do think I see this case as extremely important in terms of the digital economy, because this was in a way a case of the old economy, because it was about selling gas energy to customers. But still what the competitors were asking was access to a client's database. So you can see obviously that a client database is really very useful if you want to send out your offers and to promote your own services. So I do think it is still relevant as of today, and it's interesting to see in relation to your comments, Andreas, about this being a very important part of the new German law, that this might also be a subject that would be addressed by the Digital Markets Act. So from what we hear, access to data might be either defined as an obligation or might be subject to a preliminary study, so that the commission or the agency would be able to ask access to data. So I think that the German law will be a new element in this landscape that is very important in terms of defining the level of obligation that can be asked to certain companies. I think that now we might move to the last part of the law that we chose to address, because there are many other parts that are in this law, but I thought it was useful to say a few words about the merger control reform, because so this is not only about platforms, or this I think came from some worries that were based on the very traditional economy, but I think that it's quite interesting, and that all those who are watching this know about this part of the reform. So to put it in a nutshell, and you'll correct me, Andreas, if I describe it wrong. As you know, in 2017 there was the big change of the value transaction threshold that was introduced in Germany. So maybe you could say a few words about what is your feedback so far on this provision, because you have been applying it for 3 years now, and this was an important change in terms of the debate about some missing elements in terms of merger control. But now we see that there is a new possibility in the law that will enable the Bundeskartellamt to request notification in specific sectors of the German economy. So that is section 39A of the current draft. And according to this provision, once this specific sector is identified by the Bundeskartellamt, in certain conditions, the Bundeskartellamt could ask notification, and the conditions are that the undertaking realizes more than 500 million euros of turnover, and that the target realizes more than 2 million euros of turnover, of which 2/3 would be in Germany. And the substantial condition would be that there are indications that the transaction might restrict domestic competition. So from what I read, I know that this provision was, one of the inspiration was that certain companies in Germany had been buying a lot of small targets in some sectors where the competition was not very high. So that is of high interest for us, because we also proposed a change to the national competition law in terms to so as to address this type of conduct in which today it is not easy to look at those transactions. So maybe can you explain what is the rationale behind this new mechanism, and how will you specify or choose the sector of the economy that could be concerned by this measure? And do you have an idea of the criteria that would lead you to choose a sector of the economy? Is it where there is a very dominant company or very few competition? Maybe you have some ideas. And could this provision apply in digital markets, or is it more something that we can consider to apply in the traditional economy? So far, this still exists, which isn't sure.
Excellent questions, Isabel. I hope I can answer you as well. To start with the transaction value threshold, you know, the idea behind is always the same. It's to catch the so-called killer acquisitions. That is mainly these acquisitions by mainly big companies, and we all know that this threshold is debated worldwide. In Germany, it was very much triggered, like the debate in other countries, by the Facebook WhatsApp case, and that was well, one tried to find a solution. If you discuss these kind of provisions, there's always a bit of a regulatory tension. One is that, of course, policymakers want to put us in place to catch these kind of acquisitions by huge companies, buying up small companies, maybe preventing innovation, preventing competition in the future. That is the rationale behind it. On the other hand, we must acknowledge that many of these startups are not potential future competitors, but they have been founded and they have been established to be bought to one of these big companies. So if you want to have a lively startup scene in a country, in a certain capital, there's always this tension in how far you want to go in prohibiting these kind of acquisitions. This transaction value threshold was very much initiated by the Monopolies Commission, not by the Bundeskartellamt. The Monopolies Commission, you know, it's an advisory body in competition matters to the government. It was introduced in Germany in 2017. We are about now to do an evaluation for Parliament of this threshold that might probably still happen in the framework of the ongoing debate about the 10th amendment. So what are our findings after 3 years of experience? One is we have seen formal applications 31 in 3 years. Which is not a very large number, but they were interesting cases, let's put it this way. But in fact, it's less than 1% of the total notifications that we receive every year. So it was not that much. When we started the debate about the transaction value threshold, there were two fields where we anticipated debates with the companies. One was a question of how to calculate the amount, how to calculate the transaction value. The other one was the local nexus, because the law always also says that the target has to have a certain local nexus. So we thought it might be very difficult to discuss the turnover, the transaction threshold, but that was not so much the case. That was in the end clearer than we thought. Most debates that we had was about the local nexus in these past years. 1/3 of notifications that we have seen was eventually withdrawn after notification because we informed the parties that they were not notifiable due to the lack of the domestic nexus. That is quite a high percentage from my perspective, but it went that way. Many people expected that most of the notified transactions would be in the digital markets, but what we found is that around about 45% of the notified transactions were not in the digital market, but in the pharmaceutical industry. Biotech industry was an important client as well, and only 13% of the cases were notified in digital markets. So these are the figures. There were a lot of interesting cases that we have been dealing with under the transaction value threshold. That is one point. And of course, what we do not know is which kind of transaction were not even notified due to the fact that they had to be notified and that companies had to apply for permit of the Bundeskartellamt. That, of course, is difficult to say. So I think we're still in the middle of the evaluation now. It's too early for me to say it's good or not. And but I think all in all, it's a very interesting experience. At least we have seen interesting cases. Plus, it is difficult to say something about the gray field of not notified cases. So it is not so easy to give a clear assessment of the value of this threshold.
One comment about what you have seen so far. It's interesting because there is a lot of debate about killer acquisition or enveloping acquisition in the digital world, but the figures you have given illustrate the fact that a lot is happening in the pharma and the biotech industry. So that's interesting to keep in mind that those type of transaction can happen all across the economy, but certainly in those two sectors. And also there was a huge debate about the fact that this new provision would create some administrative burden for companies and legal uncertainty in terms of being obliged to notify and not knowing if they would fit into this framework. So you have said that companies have been cautious and have discussed with you, and you have told them in some cases that it was not necessary to notify because there was not a legal local nexus. And I was wondering, because you have taken the effort with the Austrian competition agency to provide some very detailed guidelines about how to interpret the law and how to know if you should or shouldn't notify. And do you feel that the business community in Germany is now reassured in terms of legal uncertainty or administrative burden linked to this specific provision? Do you feel now that everyone knows more or less when it's necessary to notify or not?
Well, at least I'm not aware of a huge amount of complaints about this provision, but that might stem from three facts. One is, you already mentioned it, we set up very early on guidelines on how to apply this provision together with Theo Tanner and the colleagues at the BWB, at the Austrian Competition Agency. So we try to get some clearance into the process. Second point is the Bundeskartellamt is known for quite a lean process in terms of merger review, at least in first phase. We haven't seen any phase 2 cases, by the way. I haven't mentioned that. I forgot to mention that. And we have not seen a prohibition under this provision. So, well, having said that, I think that parties also here have benefited from the quite lean procedure that we have in first phase cases. The third point is, and I hope that has become clear, we gave a lot of advice. I mean, companies came to us asking, is that notifiable or not? And we tried to be as helpful and cooperative as we could. So that might have helped to avoid these kind of discussions, but we have had them. But I think we have managed quite well in order to deal with it. So I cannot tell you if the business community, if the lawyers and economist community is really calmed by what we have done in the past. But again, I'm not aware of a huge amount of complaints about the application of this thing.
Well, at least this is an interesting way to have implemented this innovative provision when we are considering the changes that will be implied by the change of position of the European Commission in what regards Article 22 of Regulation 2004, which is another change in terms of the global merger control system. So maybe just to finish with what we were saying about the new provision about some specific sectors of the economy, do you see some, will there be some obvious targets in terms of sectors and company that should notify, or is it something in which you need some time to think how to apply this new provision?
Yeah, I mean, it's a lot of responsibility because, at least from my perspective, this is for the first time in Germany that we are the ones who say which transaction has to be notified and which doesn't. You have mentioned already the turnover thresholds of this provision. So indeed, it targets the fact that we have some huge companies in Germany which on at least partly concentrated markets buy off the markets small companies that do not fall under the turnover thresholds, and just we move towards an even more concentrated market without that the Bundeskartellamt can do anything about it. We see that very much from my perspective, in the waste management area, where when it comes to public procurement by the municipalities, we just see one or two competitors that ask to be the ones, which is not very much. So I think we have really lost some competitive moment here, and this is something that I'm very much aware of. Again, also here, we do not have a list of companies that falls under the scope of this provision. From our perspective, it was not so much designed with respect to digital markets, because again, we have an elaborated merger system, quite low thresholds in Germany. So we have the transaction value threshold. So we might be able to deal with that to a very large extent. It was more directed to the offline economy and certain developments here in certain branches, not only, by the way, in the waste management branch. There are also others that I have on my mind. But what the legislator has said, that if you designate a company to file all the mergers they do, you have to do a sector inquiry. So that will mean for us that if we really design a company to file all the mergers in the future, we have to do a full assessment of the market. We have to know market conditions very well. Needless to say that market inquiries are a complex and lengthy procedure that you go into. So this will not just quickly be done from a couple of cases that we have seen, but this will really be the result of a full investigation into a market where at the beginning of the sector inquiry, we already have indications that competition on these markets does not work appropriately. This is what is in the law. So it's going to be a lengthy procedure, and we will have to see how we deal with it. But again, it's not so much, at least in our perception, targeted to the digital economy. It's more on cases in the offline economy that we are aware of.
Oh, thank you. So we are now moving at the last part of the discussion. We have still 10 minutes to go. So I received some questions that I would like to pass to you. So one of the questions is whether the working group that you mentioned that is thinking about Section 19A of the new Act, will it be working about a definition of interoperability in the framework of this new tool? Maybe a question I could ask in more general terms is whether you feel that in the Bundeskartellamt you will need to set up a new team to apply this Section 19A, or will you be able with the current organization to do as you do with digital cases today? Another question is whether you think that you will need some specific cooperation on this new provision with other regulators. There is a mention of the Bundesnetzagentur. I don't know what this means, but I hope that I said it right. And also data protection agencies. So does that mean that you have to set up a new network of relationship with other regulatory bodies, or is it something that you already do like you did in the Facebook case with data protection agencies?
Yeah, on the question of the internal organization for applying all these new things, we have set up a working group indeed, which is quite cross-cutting. So this is not only just from one unit; it is staff, colleagues from all the units that are concerned with digital markets. Let's put it this way. You know, we have this division of work here in the Bundeskartellamt. We have the operating, the decision divisions, plus we have our general policy division there with the unit that is doing work on digital markets. All are involved in this working group. Of course, it's got a core, but everyone is involved in this and is feeding in input on it. Mainly for the time being on Article 19A, of course, how to apply it, what we have discussed during our session here, what are the addresses, how do we tackle this and all these kind of issues. The structure of the Bundeskartellamt is not about to change. I see a lot of work, coordinating work, in fact, because we will deal with different companies on the same legal ground in various decision divisions. So there's there must be a lot of effort for cooperation, coordination among the decision divisions themselves within the Bundeskartellamt. And there is a big role, I think, for the General Policy Division. And here, those two who do work on digital markets, on legislation with regard to Article 19A, to bring all the approaches together. But this is not going to change the structure. There won't be a new team that is solely dealing with Article 19A. We will do that in the established and well-known organization structure of the Bundeskartellamt. What worries me a bit is that there might be high expectations to do many cases at the same time with huge companies. You must be equipped to do that with regard to the human resources. I think there's still some room for additional staff. We will take a close look at this towards the beginning of next year, how we deal with that. So that is, in a nutshell, we will work on this in the current organization. Cooperating with other regulators is not new for us. In the Facebook case, there was a lot of cooperation with data protection authorities in Germany. I think here we have a well-established connection between us. I don't see a need. Your German, by the way, your pronunciation is excellent. Indeed, the Bundesnetzagentur is the federal regulator for telecoms, postal services, other areas. There you see easily, these are regulated sectors. This is what is done in the Federal Net Agency. This is the natural regulator. We have well-established contacts with this agency, but to be very clear, they don't have any competence in these fields. And I'm always happy if anyone contributes, but I do not see that we need to establish new mechanisms of cooperation and coordination with the Federal Net Agency in this respect. But we have, of course, a well-established mechanism for cooperating if necessary in these areas where we have joint and parallel competencies.
Thank you, Andreas. And I think I have time for a last and very precise question that came from YouTube. It's about the press and the recent French decision concerning Google and its relation with the press publishers in terms of the ancillary rights. And the question is, that the Bundeskartellamt in 2016 found no evidence for an abuse of market dominance by Google in terms of its relation to press publishers. And the question is, how do these two decisions relate to each other? And will the proposed revision of German competition law allow for a different assessment of Google's conduct once the EU press publishers' right is implemented in Germany? And so that is a very precise question. I don't know if you feel that you are in a position to comment on that, but I give you the floor, Andreas.
Maybe I don't give such a precise answer to that very precise question. That is a topic that is high on the agenda around the globe. I follow very closely what is happening in France, in Paris, and what you have initiated there. I follow very closely what Rod Sims does in Australia, what the ACCC, our sister authority down under, is doing on that. And everything else remains to be seen in the future, I would say. But that is a topic that I watch personally with a keen eye. Let's leave it to that.
We will be now reaching the end of the discussion. I have to say, I do hope that all the viewers have found it as informative and interesting as I have. And I would like to say that in those difficult times that are ahead of us, it's really a pleasure to have such a strong cooperation, relationship, and even I might say friendship with our German colleagues and with Andreas. And I'm really hopeful that this year, 2021, we'll see some really major steps ahead in the different fields that we have been quite active in the past in France, in Germany, and at the level of the European Union, of course. So I really hope that somewhere next year we'll be able to have this type of meeting at the Autorité as we usually do, and we can end with a coffee and discuss with the audience in the room. But for so far, we have to do with those digital platforms, and they can be quite useful when we try to reach an audience all over the world and not having any sanitary risk with COVID-19. So I really wanted to thank you most sincerely, Andreas, for accepting to participate in this discussion and for giving us really your first impressions in the law that, of course, has been prepared by the government and will be discussed in Parliament. But it's interesting to have really your thought, and I know that you have been really following very closely this law, even though it is, of course, a decision to come by the German Parliament. So once again, I thank you, and I hope that all the viewers will have enjoyed it as much as I have.
Thanks a lot, Isabel. I'm really looking forward to our future cooperation, looking forward to our next Franco-German Competition Day, and I look forward to these personal meetings that are so important from my respect. But this is a good substitute, and this is something where we can really exchange thoughts. I was very happy to be with you. I wish to you, to the whole Autorité, and all those who have been viewing this, all the best, and better days ahead, maybe, than we have seen this year. It's a difficult year in a way, 2020, and well, I hope it's going to be less gloomy in the future. But again, let's keep up these normal things that we have here among us. I'm someone who believes in institutions, and I think in this shaky world, it is important to have institutions that stand firm and do their job, not clicking away what is happening outside their space, being aware of it, but still doing their job. And I think this is our task for the time being. Maybe this is a small contribution to make this a bit less gloomy, what we see right now. So in this respect, many thanks for setting this up, and hope to see you soon.
Thank you, and a good day to all. Thank you again. Bye-bye.
Bye.